Good morning. Today we are going to look into arbitration in the Indian concept. Now, arbitration is an effective alternative dispute resolution. It is the forum in which parties by an agreement between those chose of a forum other than the court of law to resolve these disputes. The reason behind the evolution of the arbitration is to minimize the burden of the shoulders on the court of law and provide speedy remedy parties. Now, Nani Palkiwala observed that these are the enormous advantages in the arbitral proceeding, which I'll be saying now. So, in the words of Nani Palkiwala, he said that if the law is not to be a system of tyrannical rigidity, but insists to be the efficient and useful servant of a changing society, it must be from the time be adapted and the past of its replaced. A court of law is like an ancient castle consistently under repair. There comes a time when it is no longer pays to patch it up and it is better to resort to a new compact house built on modern life. Now let's look into why arbitration is preferred over judiciary. So arbitration is an effective forum which provides speedy remedy than judiciary. Matters in the arbitrations are disposed within 1 year, whereas in courts, the parties of the disputes have to wait for several years, depending upon the complexity of their cases. So, arbitration is also preferred by the parties because of the autonomy granted by it and the exercise by the parties in determining the course that the proceedings may take. Now let's look into the types of ADR methods, and one of amongst them is definitely arbitration. So arbitration is a dispute resolution process which is governed by the Arbitration and Conciliation Act 1996. Parties to the arbitration agreement and the court have the power to appoint the arbitral tribunal which will resolve the disputes between the parties. The provisions of Part 1 and 2 of the Arbitration Conciliation Act 1996 are amicable to arbitration proceedings. The arbitral tribunal will pass the arbitral awards which will be binding on both the parties and will be enforceable by the court similar to the court degree. I hope you understood what alternative dispute resolution is in the Indian concept. Now let's look into the history of arbitration in India. Third-party settlement of disputes is a part of ancient Indian ethos and culture. However, the settlement of the disputes through the institution of the judiciary is a little over a century old and is a result of British rule in India. Despite the long history of the settlement of disputes by alternative means in our country, the first statutory recognition given to the domestic arbitration was given by the Indian Arbitration Act 1940. Now, the retired law professor of Osmania University, who is Dr. Nageshwara Rao, presented an overview of conciliation proceedings under the Arbitration and Conciliation Act before the Law Commission of India, and he stated that the settlement of the disputes to the reference to the third party has been a part of practice of or body of customs for India for the time immemorial. So I hope you understood what arbitration is in the Indian concept. Thank you.